Mr. Lightfoot.
Yes, I'd like for the record to say that I am the first Monroe County legislator to receive the esteemed award of the Dennis A. Pt3 Elite Institution. We are named after Dennis A. Pt3, and I'm very proud to be the first legislator to receive that distinction.
Well deserved. Well deserved. Mr. Buckner.
Mr. President,
Mr. Haney.
if I could, Mr. President, I'd like to ask two follow-up questions for the discussion we had before that weren't really apropos to the item that was before the legislature. The first question, Mr. President, has to deal with an interesting lawsuit that the cities of San Francisco, Los Angeles, and Stockton, California have filed. They are suing the bond insurance companies. The theory of their lawsuit is that the bond is that the bond insurance companies prevailed upon the bond raters to downgrade municipal bond ratings, thereby sort of forcing municipalities to buy bond insurance that now is proving to be relatively worthless because the bond ratings of the insurance companies have dropped below the bond ratings of the municipalities that they were insuring. My question is, and it certainly isn't something Monroe County would want to do on its own, but I'm wondering if in collaboration with NISAC or some of the other, and I'm certainly not an attorney, but whether in collaboration with NISAC or some of the other major counties of the state, or maybe even with the state attorney general's office, that we should consider such a lawsuit ourselves in light of what's been happening. And my question, Mr. President, is whether we've given any consideration to such an undertaking.
Through the President, I have to say that topic was discussed not that long ago at a informal meeting of the County Attorneys Association of New York State. And I have discussed it with administration officials, so I think we probably will follow up with NISAC and CASB.
Thank you. The second and final question, which also comes off of the fiscal chaos that the nation has been enduring in the last month, has to do with the way our cash deposits are protected. The county at any point in time has very sizable cash funds available for a number of reasons, frequently well in excess of $100 or $200 million. The traditional way of securing those has been that the banks that were holding the money deposited in the trust department of that same bank federal securities that are in the name of the bank, and they put them in an account in the trust department, presumably with the county's name on that account. And I realize that this is the way it's always been done. And it was always accepted on the premise that, well, we only deal with the biggest banks in the country, and the biggest banks, if the biggest banks in the country aren't safe, we all might as well cash our chips in. Well, unfortunately, in the last 2 months, we've seen a couple of the biggest banks in the country, not ones that we've at least traditionally done business with, in effect, go belly up. And my question is, in light of that, whether we are really comfortable with having those collateral securities remaining in the name of the banks interest they pay us on our investments. If they had to go that extra step and retitle the securities in the name of Monroe County rather than wherever the money is, I don't know where it is. But given the events of the last couple of months, I'm wondering whether we should be considering, or whether we have considered changing our collateral policy in that regard. There always was a technical question that what we were allowing the banks to do did not satisfy state law. Although I say it was always done that way, so I'm not saying anybody's changed anything or anything else. But in the light of the activity of the last month, should we be changing the way we have our money collateralized?
To the President, right now we do monitor that collateralization and the collateralization agreements that we have with each of our banks at a minimum on a monthly basis, depending on the size of the deposit. It has come up in conversation as to what's going on with the banking industry right now, as to how we should, going forward, look at that. You're 100% correct in your assessment that every time we would ask the bank to change that agreement or change who it's deposited with or what title, the name that the collateral is with, would decrease our interest rates. At the present time, we feel that the banks that we're dealing with are creditworthy from the standpoint of holding on to those deposits and feel very comfortable with where the collateral is being maintained. It is something that we do look at, and definitely would challenge each of the banks again to take a look at what the cost would be to change that over. But at the present time, I don't feel as though we're involved in anything that would potentially subject us to loss of principal as far as the dollars that we've invested with each of the banks that we invest with.
Mr. President, I'd like to request that a report be presented to the Ways and Means Committee at its next meeting, and you can pick a date like September 30th or something. It shows where the county's money is, how much is where, and how it's collateralized.
To the President, we can prepare that report for you.
Thank you very much.
Dr. Quattro.
Mr. President, I move that this honorable body stand adjourned until Wednesday, November 12th, 2008 at 6 p.m.
We are adjourned.